Guys, hello. Today we have the Mercedes AMG E63 with a 612 horsepower engine for review, and attention, all this joy will cost you $3,076. Yes, you heard it right, $3,076. According to the contract, this is the price of the car. It's hard to believe that the car can cost this much, right? I doubt anyone will believe it. Even the most reasonable person wouldn't. But you know, even the judge didn't believe it when she saw that the car was priced this way. Today, we're focusing on a Mercedes that was bought at a reduced price. Although, to be precise, its value was actually market price, but at the seller's request, the contract listed a price lower than the actual one. And it was at that moment, when they wrote the price of $3,076, that the first brick was laid in the nightmare that would later haunt the buyer of this car. It won't be a surprise to anyone, but for several years now, individuals have been able to go through bankruptcy procedures. So to explain how this situation unfolded with the car, and more importantly, how a similar situation can happen with any vehicle, I want to point out that anyone who buys a used car and undervalues its price in the contract could become the hero of such a story. Let's break down how all this works. The car was bought. In our case, the car was purchased 8 months ago, registered, everything seemed fine. The person even forgot that the price was lower than the contract, but then they get a notice, a lawsuit. This of course is a shock, but the person never thought they'd be part of a large legal process. The seller who asked to lower the price in the sales contract is going through a bankruptcy proceedings. Now all their transactions made over the last 3 years are subject to review. The car was bought at a reduced price. And now there are signs that the seller, knowing that they would soon declare bankruptcy, started getting rid of assets by selling them at a lower price. However, the buyer can't be considered innocent because they must have known that the car was worth much more. In the end, a transaction that seemed completely legal could be cancelled, and this process might take a whole year while the court decides who is right. So, if you buy a car at an obviously lower price, you risk ending up in such a situation. If the bankruptcy administrator or other participants in the bankruptcy lawsuit discover that you have a connection with the seller, for example, you bought the car from your colleague or even from a relative, it could raise suspicions of collusion. So, if the seller claimed financial difficulties and offered you a car at a reduced price, or if the transaction happened between close individuals, this whole story could be disputed. Moreover, the period within which the transaction can be reviewed extends up to 3 years if family ties or business relationships are proven. As you can imagine, this situation is extremely unpleasant. It's very difficult to prove in court that you really paid $61,536 for a car, when the contract states only $3,076. The judge, of course, won't believe you. He'll say, it says $3,076 in the contract, and did you pay in cash? And here's where the most interesting part begins. During the court proceedings, an independent expert will be appointed to assess the value of the car at the time of the sale. At this point, it will become clear that the car is worth much more than what you paid. The price stated in the contract will be significantly different from the market value. Everyone involved in the process will realize that the transaction, to put it mildly, looks suspicious, and it is possible that it will simply be annulled. The car will be taken from you and placed into what is called the bankruptcy estate. This is the bankrupt person's property, which will be sold, and the money obtained from the sale will go to settle their debts with creditors. So if you bought the car for $5 million, but the contract states only $3,076, you are likely not to get anything more than those same $3,076. But that's not all. If you have money in bank accounts and you manage to sell the car or transfer the funds into assets that are inaccessible for seizure, you might be forced to return the difference of $58,284. This would mean that you would become a debtor in this situation and would have to cover the entire missing amount. If you think that selling the car and getting rid of assets will free you from the debt, you are mistaken. The same problems could arise in the next transaction if all the legal aspects related to the transfer of property are not properly followed. If the buyer can prove that they acted in good faith, they will be left alone, but that won't relieve you from the debt. Also keep in mind that if the transactions occur between relatives, the situation becomes even more complicated. Often people try to outsmart the system. For example, they might intentionally transfer their assets before declaring bankruptcy to hide them. Some might think, well, I can transfer the car to my grandmother or friend and then declare bankruptcy to avoid the debt. But here's the problem. All such transactions can be disputed in court regardless of how much you listed in the contract. Even if you stated the full market value or even gifted the asset, that still doesn't mean the court will recognize the transaction as legal. Judges, based on legal practice, are well accustomed to such tricks. And if the price is undervalued by even 20%, that's already grounds for investigation. If the price is lowered by 30 or 50%, it will be very difficult for you to prove that you didn't attempt to deceive the system. Now the truth is, no one can predict exactly what will happen to you or your seller in a couple of months, half a year, or a year. Everything can change in an instant. For example, I can't predict who of us will file for bankruptcy or who will find themselves in a difficult financial situation. If I could foresee such things, I'd be probably sitting somewhere on a list of the most successful people on the planet right now, and you'll be watching me on TV instead of reading my text. But unfortunately, I don't have such abilities, and neither do you. However, there are ways to minimize the risks of getting into such a situation. The first and most important piece of advice is always to list the true value of the car in the contract. If you're buying a car for $1 million, don't undervalue it in the contract. Write that the car costs $1 million, and that's it. This will save you from many headaches. And one more important point, make sure to document the transfer of money. The best option is to do this by a bank transfer, payment through a bank cashier, or online payments. It's important that your payment document includes the amount and the purpose of the payment, such as for the sales agreement. This way, you'll have official proof, and if something goes wrong, you can always go to court and show a bank statement confirming that you paid the exact amount specified in the contract for the car. Therefore, your main task is to lay the groundwork to prove your good faith in case any problems arise. If you weren't helping someone hide assets before bankruptcy, and if you truly bought the car at a fair price, then you have nothing to fear. If everything is done correctly, the courts will sort it out and recognize your transaction as legitimate. Of course, another useful piece of advice is to check the seller and their history. This is especially important when dealing with cars that have had multiple owners. If the car has more than one owner, it's recommended to check whether it was ever collateralized and ideally verify the seller through registries, such as those available through bailiffs or arbitration cases. Knowing all these details will help avoid many problems in the future. Now, imagine this situation. There's the seller, a buyer, and the third party involved. The seller decides to sell the car, and the buyer comes to purchase it. And here's where the classic scenario starts. The seller offers a huge discount, saying something like, "If you buy it now, I'll give you a good price." But then the seller asks to list the lower price in the contract to avoid taxes. Sound familiar? Probably a little too familiar. The buyer, of course, agrees because the price is really great and the seller seems honest. But then after some time, the buyer finds themselves in court where it turns out the price was undervalued and now all the documents are in question. And this is where the problem doesn't just involve taxes but also potential legal consequences for both parties. What happens next? After a deal is made with an obviously undervalued price, bailiffs may come to you with an enforcement order. You'll be placed in line with other creditors, and the money from the sale of the car will go to settle the seller's debts. If you don't have anything of value, it's likely you won't receive much in return. As you can understand, this whole process is far from pleasant, especially if you ended up in it by accident. That's why it's always crucial to carefully check all the details of the deal. If the seller insists on listing intentionally low price, think carefully whether you should go ahead with such a transaction. If you do decide to go ahead with such a deal, be prepared for unpleasant consequences in the future. When a purchase is made at an undervalued price, it opens the door for potential claims from both the court and other parties involved in the transaction. If the price is 20% below the market value, the court will already be suspicious. And if it's 30 or 50% lower, then you will definitely find yourself under legal scrutiny, and it won't be easy to justify yourself. This way, you will protect yourself and prevent any opportunities for manipulation with documents. In the case of legal proceedings, these pieces of evidence can play a crucial role.